Hey out there, legal warriors. Anti-harassment orders. What can they restrain? And more importantly, what can't they restrain? If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, I said I'm a criminal attorney, right? Well, we also handle quite a few restraining orders. And in Washington State, the legal term is protection order, but most people that call us talk about, hey, someone served me with a restraining order. And sometimes people call us up saying, hey, can I get a restraining order against somebody? And there's a bunch of different types of restraining orders in Washington State. They can all be found under RCW 7.105. There's domestic violence restraining orders, assault restraining orders, anti-harassment, vulnerable adults, say that a couple times fast, right? Those types of things. And I'm going to talk about anti-harassment orders. The typical anti-harassment order is sought by somebody who doesn't have a family or household relationship with the person that they're trying to restrain. So if it's boyfriend, girlfriend, mother, father, that's going to typically be a domestic violence restraining order. But if it's neighbors or just strangers that don't know each other, people that play in the same sports league, people that had an altercation on the street, they don't have a prior existing family or household member relationship, they're going to seek an anti-harassment order. And the problem that I see in my practice and hear from people calling me on the phone from both sides, respondent side or petitioner side, is that oftentimes people are seeking an anti-harassment order to restrain something that the statute, the law, does not allow the judge to restrain. And why do so many people seek anti-harassment orders for things that the court can't restrain? It's because of the police. Right? If you're a police officer and you keep getting a call about feuding neighbors that, hey, the neighbor's throwing garbage on my yard, or they're playing their music too loud, or the dog is loose, or they gave me a dirty look, there's no crime committed probably in those situations. And therefore, the police officer dealing with a very upset and irate citizen calling them, why won't you fix this, police officer? The police officer says, go get a restraining order. And then they go to the court, they get the restraining order packet, they only fit under anti-harassment, but they check that one, and they start to ask the court to do all these things they can't do. So take a look at the statute, RCW 7.105. You can look up the definition of unlawful harassment. To get an unlawful harassment protection order, one needs to show that the bad person, in this case the respondent, if we're the petitioner, is using a course of conduct directed at the petitioner to cause them severe emotional distress. It's a little broader than that, but think about it that way. The petitioner has to show that they suffered severe emotional distress from the course of conduct from the respondent directed at the petitioner, and that a reasonable person in the petitioner's shoes would also suffer severe emotional distress. If the petitioner's just an eggshell and they're over distressed compared to what someone wouldn't be that distressed, well then they're not entitled to an order. But there's a caveat in what the court can do and can't do. So what can the court restrain if you're granted a restraining order? Well, they can order the respondent to not have communication with you directly, petitioner. The court can also order the respondent not to communicate to the petitioner through third parties, right? You can't, let's say the petitioner's name is Bill and the respondent's name is Chuck. Well, Chuck can't tell his best friend, hey, go tell Bill I hate him, right? That's third party conduct. They can stop electronic communication. They can stop from sending an email or liking what you have on Instagram, stuff like that. They can stop those type of things. They can keep the respondent a certain distance from your home or from your minor children that live in your home. They can keep them a certain distance from your workplace or your school if you're going to school, things like that. So why did I say in this video, what can't they restrain? Well, there's so much they can't, and it's so much of the complaints about stuff they can't do. Well, the respondent is talking bad about me in our public circle. Well, people can talk bad about us, right? They can't threaten us, but they can talk bad about us. The court is not allowed to enjoin or restrain free speech. the Constitution beats the civil law, RCW 7.105. So many times these respondents are out there causing all types of chaos for a petitioner just because they're running them down in public. They're running them down online. They're saying bad things. This person assaulted me. This person, is bad for these reasons and reasons I can't say because YouTube might censor it, right? For all types of things we've seen over the years. But the court's not going to shut that down, typically, because that's free speech. They're entitled to their opinion. Now, it doesn't hurt asking for it in the court anyway, because sometimes the court will order things that are illegal, right? We've had a case within the last 2 years where the court ordered something illegal against a client of ours. It got appealed. It got reversed on free speech grounds. So just because the law says the court can't do it doesn't mean they won't. But I'm talking about what the court, in my opinion, is not allowed to do. The court can't restrain the respondent from talking to people who aren't petitioners, right? You can't say, hey, court, I want you to restrain the respondent from talking to my sister. Well, the court, you don't get to decide in this hypothetical whether or not your sister wants to talk to the respondent or not, and to restrain the respondent from talking to your sister, assuming your sister's an adult, there needs to be a showing of unlawful harassment towards the sister. Again, sometimes you want a much broader set of requests to restrain the respondent than the court can even allow. And why am I even putting out this video? Why do I need to tell you this? Well, I need to tell you this because when you file that petition and it gets served on the respondent, things aren't going to get better, right? Things typically are going to get worse first. So if you file a petition against the respondent and it can't solve what you're trying to solve, is it really a good idea to file that petition if it can't solve what you're trying to solve? The petition can keep them from contacting you, keep them from coming on your property, keeping them from coming a certain distance from your property, like I've said before, but it can't solve some of these other things. It can't keep them from talking to others about you. It can't keep them from doing so many things that it's so annoying that the court says, or the police say, go get an order when you just simply can't get it. So what I want you to do before you go file your order is typically reach out to an attorney if you can. Now, we've had a lot of people reach out to us lately, even some people upset with us because we couldn't get back to them to tell them if they had a good case or not. Attorneys are busy, and so you may have to contact more than one if you're a petitioner trying to get a restraining order against someone. But if you're not sure whether or not the court's allowed to restrain it, I usually say ask an attorney what they think first, because I don't want you to waste your time, make the situation worse, and become more frustrated by asking the court to do something it simply can't do. I'm not discouraging anybody from getting an order to try to protect themselves. The court can do a lot, but this is a particular area of the law where time and time again I see people frustrated by asking for things the court can't do. I understand why they do it, and hopefully I don't want you to ever fall into that category. So that's what I have to say. If you find it useful, please like and please subscribe. More people get to see it. More importantly, if you got a legal problem, a criminal matter, or a restraining order matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, we will be there for you. Thank you.